Returning to Centerville Mobile Home Park versus Roger and Ray Wired. They're here at the courthouse. They've been in a conference room discussing matters with Bauer from Legal Aid. The owner of the park, Christy Senzo, is here, as well as John Caputin on behalf of the park. This was filed as a termination of tenancy for the expiration of a lease for this mobile home in the park. Not just cause, just that the lease was up in April. And then we've been arguing about whether you're able to do that or not in a mobile home case. There's no just cause, there's simply the lease is up. Defendants have been paying their escrow payments each month, and they're current, and the court is holding that escrow funds. There were some other ancillary issues about other payments or other costs that might not have been readily apparent. As I indicated, this is not a non-payment of rent case, it's a termination of tenancy case. Ms. Bauer, you indicated you may have a question.
Yes, thank you, Judge. I emailed Attorney Landman after the previous hearing asking if he could have his clients provide a verification of continued residency, because my clients needed that with the post office in order to continue to get their mail. I never got anything back. I understand Dan's and Attorney Landman's had stuff going on, so I'm not blaming him or putting anything on him on that. But I confirmed with my clients again today that had we not emailed them the notice to appear for today, they would not have gotten it. They did not get anything from the courthouse in their mail about this hearing. And so I'm wondering, I know the staff always sends those out. I don't know if they were returned as undeliverable or not. That's what
I don't see them. I don't see them in the file, but I'm glad they're here. I'm glad you provided additional notice, but they aren't the only tenants that have had trouble with the mail. Centerville has a limited delivery, and they also have post office boxes in the courthouse, and they're very busy. Everybody in town's got a post office box. At any rate, well, let's talk about this case, Mr. Caputin. I don't think you can do what you're asking to do. There are two statutes that say you can't do a termination of tenancy for the expiration of a lease. You need just cause. So where are we here today?
Well, Your Honor, I think that there's a misunderstanding as to MCL 600.5775, which is the just cause termination statute in Chapter 57A. And its applicability to folks that rent mobile homes at mobile home sites, as opposed to those that, there's some feedback here, as opposed to folks that own mobile homes at those mobile home sites. And I think it's partially due to the fact that Chapter 57A fails to define who a tenant is in a mobile home park or tenancy. But then again, that's why we're here, because Michigan courts have long held that it's a duty of the courts to construe the language of the statute. In construing a statute, courts are required to give effect to the legislature's intent. So that legislative intent has to be gleaned from the statutory text if the language is unambiguous. But when a statute's language is ambiguous, and that's when reasonable minds can differ as to its meaning, and I think that you're reasonable, Ms. Bauer's reasonable, and so am I, and I think that we all have differing opinions. So I think that it's ambiguous, and statutes are generally held to be ambiguous when either one word in the statute has an unclear meaning, or when the statute's interaction with another statute has rendered its meaning unclear. And finally, when an application of the statute to the facts has rendered the correct application of the statute uncertain, like we have in this case. So when it's ambiguous, judicial construction is necessary. And in that vein, The Michigan Supreme Court has instructed that while individual words or phrases, and this is important in this case because we have individual words and phrases, while they're important, they should be read in context of the entire legislative scheme. And to that end, court has to consider both the plain meaning of those words and also phrases and placement, purpose, and it has to be read in conjunction with other relevant statutes to ensure that the legislative intent is correctly ascertained. So turning to this case, we look at Chapter 757A as a whole. And I think that that's where the court needs to first start, is looking at Chapter 57A as a whole, and not just the just cause statute 5775 by itself. And I think when it does that, the legislature's intent becomes clear that that Chapter 57A is solely with respect to owners of mobile homes and not those that just merely rent those homes. And here, I'm going to go into some examples. So if we look at, I think 600.5781. So that's right after, that's after the termination has occurred, and that refers to the sale of the mobile home on site. So it says, section 5781, if a tenancy in a mobile home park is terminated for just cause, the tenant may sell his or her mobile home on site as provided in sections 21HA, et cetera, et cetera. So someone who is renting a mobile home, well, that just makes no sense because they can't sell the home that they don't own. Also, if you take a look at the section immediately following that, 5783, and that has to do with the judgment for possession. So with the just cause termination, every judgment of possession resulting from an action to terminate a tenancy shall, and this says shall, and it doesn't say may, it says shall set forth the right of a tenant to sell the mobile home on site, the conditions of the right, and the consequences of the tenant's failure to meet those conditions. That again doesn't make sense if it's only referring to someone who is renting the mobile home instead of those that actually own the mobile home. And I think it's also important, and the Michigan Supreme Court has also stated that a court has to take a look at the entire scheme or laws related to not just that section, but other sections as well. And here we should take a look at the Summary Proceeding Act. We should take a look at the definitions under MCL 500-701. Which is the Summary Proceeding Act. And in that case, definitions under premises, it includes structures, fixed or mobile, and also it includes mobile trailer homes. Okay, well, back in those days, they called mobile homes mobile trailer homes, but it includes that. So again, we have a different terminology. But the Summary Proceeding Act is meant to encompass manufactured homes. So, the Michigan Supreme Court says that a court has to harmonize everything to have it provide or give forth the legislative intent, which was meant to encompass. So, this is also a very important thing I'd like to point out is that when Chapter 57A was enacted, the legislative intent is readily discerned by the Senate Fiscal Agency's analysis of the act, and that was completed on October 4th of 1988. And there, the Senate Fiscal Agency explained the rationale for the adoption of the act, and I'd like to put that on the record, and that is that mobile home park tenants long complained that Michigan law treats those who own their mobile home but rent space in a park in the same way it treats other tenants, when in fact mobile home tenants is considerably different. Tenants in apartment building, for example, who receive a 30-day eviction notice, have 30 days to pack their belongings, find another apartment, and relocate. Mobile homeowners, owners, on the other hand, must either move their mobile home to another park or attempt to sell the home in the park they are being evicted from. Although administrative rules governing mobile home parks require that tenants be offered a minimum 1-year lease, the rules do not require leases to be renewed. Also, many tenants apparently do not exercise the right to a year's lease. As a result, whether a lease is renewed or not accepted, the park owner can give a 30-day notice to quit without cause. So they were just giving those that own manufactured homes this additional protection, which is that it has to be just cause. They were not giving those that rent the mobile home in a manufactured home park, because those are the same as tenants within apartment buildings. They have 30 days to pack their belongings. They don't have to worry about selling the mobile home, moving the mobile home within 30 days. Which a lot of times, I believe back in those days, sometimes, it affected those with lower incomes, the elderly, because they didn't have the funds or means to readily move their mobile homes from the manufactured home community. And I think, some park owners and unscrupulous park owners would take advantage of that and allow them to leave and take over the mobile home. So, I think that the intent of the act was clearly to protect the financial ownership interests of mobile homeowners. And I think here, contrary to the rationale of the act, the defendant wants the court to hold that any tenancy of a mobile home requires just cause. And I think that basically flies in the face of not only the legislative intent, but looking at the statute as a whole and harmonizing it with the entire Summary Proceeding Act. With that, we ask that this court to construe the act consistent with the intent and grant judgment in my client's favor.
That was very impressive. You've done a deep dive, very deep dive into this act.
Judge, I'm prepared to respond to each one of the points my colleague has raised.
I'm ruling in your favor.
Can I make a brief record? Because I suspect this might get appealed.
Yes, I'm expecting it will also. I'll give you a chance to speak.
Thank you.
I've never encountered this issue in 24 years. The court has always treated a lot and trailer as like an apartment. I see other courts have wrestled with this issue, and it really boils down to the definition of what is a tenant. This law was drafted in 1961. The world's a lot different than it was then. I suspect there were very few cases where people rented the trailer and the lot in 1961. I think people own their own trailer, mobile home, manufactured home. As you know, they're working on updating this legislation. There are all kinds of problems that district judges are wrestling with. The whole issue of non-payment of rent as opposed to just cause terminations and others. There is no clear answer. And I don't believe there's a clear answer to this, although you make a compelling argument, I think, which would be up to a court hearing this on appeal. All right, Mr. Caputin has done an eloquent job of stating his position, which requires some serious scrutiny of the entire act and other acts, and he has even looked into the legislative intent. Someone in 1988 is trying to determine what the legislative intent was in 1961. Ms. Bauer, what's the defendant's response?
Thank you, Judge. I'm going to address my colleagues' issues in reverse order, of which they were raised. Referencing the 1988 Senate fiscal analysis makes clear that the Senate understands the words mobile home owners. And the statute that the legislature has in place currently does not use the words mobile home owners in the just cause section or in the summary proceedings section relevant to mobile homes. Entering the arena of legislative intent is not proper when the language is clear on its face. But even doing so, it is clear that if the legislative will existed to change the statute, the legislature would have made a distinction of mobile home owners. They've demonstrated that they understand that distinction. Nevertheless, legislative intent is not appropriate in this analysis because the language is clear on its face. Also not appropriate is the need to look through the rest of the statute, but as my colleague has, let's do that. My colleague references MCL 600.5781 and 5783. 5781 says that a tenant may sell their home on site. Well, it certainly doesn't compel tenants who are renting the home to sell the home. That would be illogical, of course, right? And the statute doesn't use binding language. The statute says the tenant may sell the home on site. Not all tenants, etc. But he says, well, hold on a second. MCL 5783 says that a judgment shall set forth the right to sell. But he's got to keep reading because it also says that the judgment shall set forth the conditions of that right. And certainly one condition of the right to sell the home is ownership of the home. So the use of the word shall to in this sentence to contort the statute into saying that it was only written for tenants who own their mobile home is to read into the statute things that aren't there. My colleague also says that Summary Proceedings Act provides for mobile homes and those tenancies, and I completely agree with him. But he needs to look at MCL 600.5714 subparagraph 3. There, Summary Proceedings Act says a tenant of a mobile home park is not considered to be holding over under the other sections of the statute unless tenancy or lease agreement is terminated for just cause pursuant to Chapter 57A. Here is very clear that the Summary Proceedings Act, the act providing this court with the authority to proceed, contemplates all tenancies of a mobile home park. Now, we don't need to look at the rest of the statute if a statute is clear on its face. I submit that the statute is clear on its face and no further analysis is required. But if further analysis is going to be undertaken, the court cannot insert an interpretation that adds confusion and ambiguity to the effect of the law. So to that end, as relevant perhaps in this case, essentially two questions or avenues of thought? When or how does one draw a distinction between owner of a mobile home park and a tenant of a home in a mobile home park? Are we talking about the time at which title transfers? Or are we talking about when someone enters a lease with an option to purchase? Title certainly hasn't transferred there, and yet it is a more permanent form of home ownership. This is a different type of tenancy for sure, but it is a tenancy nonetheless. And so then that leads me to my second question, which is, if Mr. and Mrs. Wired are not tenants in this mobile home park, then what are they? They are tenants in this mobile home park. Therefore, their tenancy cannot be terminated without just cause. Thank you, Your Honor.
All right, thank you.
Can I reply?
Yes,
Because there are certain things that she wants me that counsel wants me to look at. Well, first of all, the Senate fiscal analysis has many different words for mobile homeowners. It says mobile homeowners, mobile home residents, and then it goes into residence itself. So there's many different ways that the Senate fiscal analysis actually stated who a mobile home owner is.
well, let me speak to this. I'm much less impressed with Senate physical analysis than I am with a court opinion or the statute. But I'll let you go ahead and continue.
Right, and with respect to the statute, the interpretation of the statute is to insert that those who are a mobile home renter is meant to encompass section 600-5781, because it says the tenant may sell his or her mobile home. It doesn't say the mobile home owner may sell his or her home. It says the tenant. So if we take that in the context of it encompasses both renters and owners, then we take a look at section 5714 of the Summary Proceeding Act. And it says a tenant of a mobile home park. So just taking the word tenant to mean simply both renter and owner in both statute, if you harmonize that, it doesn't make sense at all. Because taking tenant to mean both means that both can sell the home. So now if you take a look at chapter 57A, which encompasses the just cause, it encompasses the in-person conference, the payment of rent and other charges, the sale of the mobile home, the judgment of possession. If you take a look at that in the context in which all of these sections are put together, it really only makes sense. It's not illogical. It actually makes more sense than the opposite, that this was only intended for folks that own a mobile home. That's all I have.
All right, thank you. The level of advocacy here is quite high, and I appreciate competent counsel and eloquent argument with focus on the law. As I indicated, I haven't dealt with this issue in 23.5 years, but others have. And the statute needs to get fixed. We need some guidance. But as the defendant argues, this is in two places in the statute. The whole Summary Proceedings Act, which is Act 236 of 1961, Section 57, states in just the act itself, in 600-5714, paragraph 3, as cited by defendant, a tenant of a mobile home park is not considered to be holding over under subsection 1B or C unless the tenancy or lease agreement is terminated for just cause pursuant to 57A. So the Summary Proceedings Act says you can't terminate a mobile home tenancy except for just cause. And there are different rules regarding what is just cause, 3 lates and a 12-month period and other issues. Then we go specifically to the mobile home portion, which is at 600-5775, which also uses the word tenancy. The tenancy of a mobile home park shall not be terminated unless there's just cause for termination. Both of those are plain language statute. These people are tenants of the Centerville Mobile Home Park. They have a tenancy. They're renting the lot and the trailer, and they are tenants. They're not residents. They're not non-mobile home owners. They're tenants. And in 2 sections in the law, in the Summary Proceedings Act and in the mobile home section of that act, it says you can't do it unless you have just cause. The language is plain. Some other judges have wrestled with this issue, including my colleague Sarah Smolinski in Grand Rapids, who came to the same conclusion I did. All right, the motion to terminate tenancy is denied. No just cause is established or even pled. Case is dismissed.
What about the
Yes.
$7,000 they owe me?
All right, Mr. Senzo, I didn't ask you to say anything, but I'm going to release all the escrow funds to the plaintiff. So the court has I think $3,030 in escrow. That's going to go to the park. If you want to terminate their tenancy for just cause, which includes 3 lates in a 12-month period, you can do that. The law is not clear. Other judges, they cited 2 that ruled exactly the same way I did. Mr. Caputin makes a very eloquent argument, but the plain language says you can't do it. So Meg, I'm going to ask you to do an order denying the motion to terminate the tenancy, dismissing the case without prejudice, and releasing the escrow funds to the plaintiff. Mr. Senzo, the rent that the defendants have paid to the court for the last 3 months, I think maybe it's only 2. Maybe it's, I thought it was June, July, and August. I mean, June and July. So I may only have 2 months. They pay, this was June. They paid June and July. So I have $2,200, which will be released to the plaintiff. If you wish to restart this as another type of case, nothing prohibits you from doing that. But this case, for expiration of the lease, is dismissed. All right, thank you. We'll be in recess.
Your Honor, may I review the order before it's submitted to?
Yes.
I was just going to ask for your email address so that we would attempt to submit a stipulated order. Obviously, if we can't stipulate, I'll submit it under the 7-day.
Right, yeah, I'm not difficult. I'll approve it as to form if it has everything Your Honor says.
One of the problems, Mr. Senzo, is these cases they rarely get appealed. I've been cited a couple of cases, one from a district court, one from a circuit court, but they don't get appealed to the Court of Appeals or the Supreme Court. So we don't have a decision from an appellate court that gives us the answer to this question. And other judges around the state are asking the same question. I've ruled that the language of the statute was clear on its face, and you can't do this. Other people may disagree. Also, the legislature is doing a major overhaul of the mobile home law, which has been needed for 50 years or more. That may give some guidance to judges on this issue in the future. But right now, that's my view on things. All right, Ms. Bauer will send the order to Mr. Caputin, and I'll sign it when you both approve it. Thank you.
All right, thank you, Your Honor.
Mrs. Wired, you're free to go.
Okay, thank you.
And have a good weekend.